This is the part 1 of law of evidence. The first one is about privileged communications. Privileged communications means generally persons who are competent to give evidence, who are bound to give evidence, they can even be compelled to give evidence. This means that the persons who are competent by law to give evidence, that they can give evidence and they are bound to give evidence, and such person does not give evidence, so we can even compel them. Person is competent, so he is bound to give evidence. So but he is not willing to give evidence, then we can even compel him to give the evidence. But there are some cases where persons do satisfy the first two conditions, that they are competent and they are bound to give evidence, but we cannot compel them to give evidence, and such communications are called privileged communications. The Act describes a few communications as privileged communications because in those cases we cannot compel the witness to give evidence. These cases are of three types. The memory technique is PMO. Hint to remember the technique is Prime Minister's Office, PMO. First one is professional communications, matrimonial communications, official communications. Professional, matrimonial, official. Professional communications. It protects the communications between client and legal counsel. What is the purpose? Professional communications, and this is professional communication is privileged communication. Why it is privileged communication? Whatever the communications are happening between the client and the legal counsel cannot be taken as a evidence in the court of law. What is the purpose? Litigant can communicate freely, frankly, and fully with the lawyer without any fear. If there is a situation that when a client comes to us and admits the crime, and the lawyer goes to the court and takes this as an evidence, then any person would have a fear of telling the truth to the lawyer. So to protect these communications, the law has said that this is a kind of privileged communication. So whatever you discuss with your lawyer cannot be taken in the court as an evidence. Thus, purpose, litigant can communicate freely, frankly, and fully with the lawyer without fear. Lawyer is not permitted to disclose information given by his client. Example, A commits an offense and engages B as a lawyer and discloses all facts relating to commission of crime. Lawyer cannot become a witness and is not permitted to disclose information received from the client. To summarize, whatever the client tells the lawyer cannot use that as an evidence in the court. What are the essentials? When do we say that the communications between the client and the lawyer are privileged communications? The first essential is communication has to be made to a person permitted to practice as an advocate. What is the first essential? Communication has to be made to a person who is permitted to practice as a lawyer.